let's just go first to what the court has decided. There is a prima facie case. The family should stay until their case, or the case of the 2-year-old, goes to a final hearing. What do you make of that?
Well, that's obviously a decision that the court's made, and we respect that. We've been very clear from really day one with this family, from the first time they've told their story, that every adjudicator within the department, every court process has been very clear to the family that they're not owed protection, and that remains the view. And the court process will be respected. We'll go through that process. And
except for the 2-year-old here, which is what this is all about now, Tharanika.
Well, the question is whether you can make out different facts in relation to the youngest child that haven't been made out in relation to the other members of the family. Now, that's an issue for the advocates.
Well, right now it seems to be whether her case should be properly looked at by the department, right? And whether the bar, as it's called, should be lifted for her case to be considered by the department.
Well, Minister Coleman's already gone through a process in relation to the youngest child, and our position is that they should leave as soon as possible, and we're happy to make arrangements for them to return.
That position is not to consider her case because the parents came on boats,
no,
is that right?
Minister Coleman's already looked at the particular case of the youngest child. Now, he's the decision maker in relation to the youngest child. Matter's already been referred to him by the department, but I don't want to comment on the nuances of the case because we've just had the decision. I'm waiting on advice, so I've only seen a summary of it, and this matter will go back to the court. It may well go to the High Court.
There is just one point, though. They're pointing to a decision you made as Minister in July 2017 about lifting this bar that prevents the case to be properly heard. Do you know what they're talking about?
David, look, there are lots of delaying tactics, right? Let's be honest about it. If there's a case to make, let them make it. The judge is going to set down a date. We'll wait for that date. We've been very patient now for a number of years in relation to this family. It's very difficult because you've got 6,000 people behind them in the queue, and there are 1,500 before them who have gone back to Sri Lanka already.
Would you rather they'd been put on a plane?
I'd much rather that they accepted that. I think it's in the best interests of their children, frankly, of themselves, and I think even Mr Albanese and Labor now have done a backflip in relation to this particular family because they know that the case is without merit, and
we're not sure they've done a backflip.
Well, Mr Albanese's never mentioned it again.
Now, in the meantime, while we're waiting for this case to be fully heard, will they stay on Christmas Island?
Yes, they will. Yeah. So the advice from the ABF Commissioner to me, particularly given that when we tried a removal from Victoria, that advocates and campaigners cut the fence at Tullamarine Airport and attempted to chain themselves to the front of the aircraft. The advice to me from the Commissioner is that it is in the safety of, bearing in mind the safety of his officers and the safety, frankly, of the family as well, that Christmas Island is the best location, and that is where the family will stay until this matter is resolved, hopefully within a matter of weeks. Do you accept that they're isolated there? No, I don't. Just to be very clear, they're not in the detention centre. This is an area where Labor had people accommodated. We've done massive upgrades to the area. A house? Yes, they are. And there's a pool close by, the school's down the road. The kids are able to go there? I've given the department the direction that we want whatever support is required for the children, support for the families, medical assistance. There are Australians who live on Christmas Island otherwise. And again, the advocates will throw all sorts of spurious claims up. But for me, I've got to act in the best interests of the family and of the ABF officers. And I'm not going to have a situation where we bring this family to Perth or to Darwin, for example, and we've got advocates who are barricading and causing disruption at a motel or somewhere where the family might be kept until they can be deported. Do you think the parents, Priya and Nadis, had so-called anchor babies? I think, David, as you look around the world, it is a very well-known practice. And look, you and I... is that what's happened here? So you and I as parents, if we were living in a part of the world and we wanted a better future for our children and we thought Australia was that future, frankly, I would do anything to provide that outcome for my children, as you would. And this family was told well before they had children that they were not able to stay in Australia, ever. It was made very clear to them. And 50,000 people came on boats.
But how do you know that's why they decided to have kids? That could be for a number of reasons.
Again, David, it is a well-known approach, and this family can speak for themselves. But I've looked very closely at this case for a number of years. This family was told before they had children that they were not entitled to stay in Australia. They've made out,
you accept that as a loving couple, they may well have decided to have kids.
Of course, and they've made out now, part of their case and their significant claim, and particularly by advocates, is that they've got children who don't know anywhere else but Australia, and therefore they must stay. Now, you can interpret that.
But you don't know the reason for having kids is to get an immigration decision.
Well, David, I've given my interpretation of it.
But how do you know?
Well, what I know is that there are thousands of cases that you can point to around the world where that is a tactic. And this family was told before they had children they couldn't stay. They've had children, and now the claim is that they must stay because the children don't know Sri Lanka, they only know Australia. You can draw your own conclusions.
If they are sent back, will they incur the debts?
No, they won't.
So the detention, the flights?
No. Again, spurious claims by advocates. I want to see the family settle peacefully back in Sri Lanka to restart their lives there.
Is that normal that they wouldn't have any debts?
Yes. It's pointless because it's impossible to recover. If there are certain circumstances where we think there's significant fraud involved and people have means, perhaps you could pursue it, because in the end you're dealing with taxpayers' money, but the reality is in most cases you'll never recover that debt.
Labor points out you've used your ministerial discretion power a lot, or either you or the decision maker, David Coleman, 4,000 times. Why not this time is their point. Can you explain this discretionary power? When is it used and why?
Again, David, I mean, it's just such a ridiculous claim that's made by Labor. Now, either they don't understand how the system works or they're deliberately misrepresenting it. So let me give you an example. In relation to this family, I've intervened on 10 different occasions. Don't forget that there are thousands...
Using this power?
Yes, exactly. This is not a power to settle people here permanently on their way to citizenship. This power, for me, has been used significantly and probably more than most other ministers.
So how have you used it with this family?
Because I've brought them out of detention and allowed them to live in the community. And then I've allowed...
On Christmas Island, you mean?
No, in
Biloela?
In Biloela, for example. And I've allowed work rights and for kids to go to school. And each time I make that decision for the bridging visa...
So this 4,000 figure is all of these?
It includes all of that. Now, I have never acted under the powers that I have under the Migration Act in a similar case to allow those people
so
to stay permanent.
Just what you said there, you've never... Well, let me ask you, have you ever used the power to let someone who's come by boat to stay in Australia?
Yes, I have. So for an interpreter, for example, it's provided assistance to us in the Middle East that's helped work with our troops and provide support to us. So,
and they came by boat.
So there are other equities in that decision,
right.
And there are other circumstances.
Anyone else?
But you're talking in a couple of cases.
So two or three times?
Two or three cases.
So an interpreter, there was a young boy, a Rohingya boy?
That's right. The two interpreters, as I recall, and a stateless orphan, I think, is the...
Yeah. So the threshold to do that, you've only done it 3 times. The threshold to do that is what?
Well, it needs to be in a very specific set of circumstances like those I've just outlined. So... But the government's been clear that...
No, but I'm just trying to know what that is. If you're an interpreter, help the Aussies in battle?
We've said as a rule, if you come by boat, you aren't settling in Australia.
Except for these 3.
Well, again, in terms of intelligence that we might receive in relation to an individual about... And because we're talking about a couple of cases, I'm loath to go into the detail because they might be able to be identified. But where we've worked with Defence, for example, or... our international partners to identify somebody that's provided support to us in the theatre of war, for example, well, that is an extenuating circumstance, and there are real issues in returning that person back because they may well face certain death, etc. But in relation to a family, similar facts to this one, never. And we've been clear that given 1,500 people have gone back, same young girls and boys in family units that have gone back, you've not heard it, of their cases because the social media hasn't kicked into, to
And presumably there are others in Australia.
There are 6,000 people behind.
How many Tamil families with kids?
I don't have the exact number.
Are we talking hundreds?
But I don't have the exact number, but we know that the civil war was done in 2009, and we know that no court, let alone the decision makers within the department, has decided that this family has any case to make as to being refugees.
Can I turn to another issue? You've introduced legislation today seeking to make it easier to strip Australian citizenship from dual nationals. Basically, instead of the decision going to what's called the Citizenship Loss Board, when someone goes to a prescribed zone as a terrorist, it will go to you to decide. Why the change?
That's the recommendation from the Independent National Security Legislation Monitor. So we introduced legislation in 2015. There are 14 Australians that, because of their own conduct or convictions potentially, there are three limbs to it, or their association with a listed entity, a terrorist organisation, for example, so in those circumstances, 14 Australians, because of their own actions, have renounced their citizenship. Now, at the time, there was debate and a discussion about how the legislation should be constructed.
Within the Cabinet?
And with the Solicitor General, there were constitutional questions, etc., as to how it should be constructed. And the advice at the time was that the safest way to construct it was that it was an operation of law. That is, it was because of the conduct of the individual, they essentially self-renounced their...
I'm told George Brandis insisted on this.
So let me finish, because it's an important point. So that's the one model.
Yep.
The Insulam now has had a look at this 4 years later, which is part of a standard review, which is fine. And his judgment is that it should be changed.
But you said the Independent National Security Legislation Monitor has recommended what you're now proposing.
Yes.
Is that right, that they've actually recommended it?
Yes, it is. So that's the recommendation. We've also taken a number of decisions otherwise in relation to legislation. So the thought that this is some additional power is a nonsense.
In practice, though, it's going to mean this law can now be used to reach back to offences from 2003?
Yes.
Why is that?
Because that's when the offence was introduced in relation to, under the current legislation in 2003.
Didn't the Independent National Security Legislation Monitor also say that it should be retrospectively repealed? You mentioned the 14 who've lost their citizenship.
Yeah, well, we didn't agree with that. So
what happens with them?
That arrangement
you won't
stands.
restore their citizenship.
David, we're talking about the worst people in the world, right? These are people that would come into Australia and would blow up people sitting in a food court. Let's be serious about who we're talking about here. So I'm not going to reinstate citizenship for those people under any circumstance, and I'll have a look at new cases that come forward. But we have said that I think there was a mistake made in the original legislation, which had application only from the date of assent, which was in 2015. It's like saying that the war crimes were committed between 1939 and 45, but because the legislation was introduced in 45, it would only apply to conduct post-45, which is an absurdity. So for people who were fighting in Syria, Iraq, Afghanistan, wherever it might have been, back to 2003, they are captured, as they should be. There are rights that they have to appeal judicially through the courts, but I need to deal with the threat that we face of returning foreign fighters, and it's very real.
Do you accept the government got this wrong, stuffed it up in the original draft?
No, I don't. I mean, there was a lot of advice in relation to the constitutional restrictions as to what we could do, and the advice of the Attorney-General of the day was that that was the better course. People have now had the benefit of 4 years of operation of the law, and the recommendations come in from the Insulam. He has a different view of, or different interpretation. We've accepted the recommendation. The report, the legislation now goes off to the PJCIS, to the Joint Committee on Intelligence and Security, as it should.
And if it goes through, if they give it the tick?
Well, if it does. I mean, Mark Dreyfus seeks to water down every piece of legislation.
Well, we'll see. If this goes to end of the day, this would give you a fair bit of power, wouldn't it? It'd take someone's citizenship away.
And again, David, it's judicially reviewable. There's natural justice at different parts of the process. It can go to the federal court or to the High Court, and people can review the decision. But in some cases where we can prosecute, we will. But it's very hard to gather evidence that's admissible in a court of law here, where people have conducted mass murder on the battlefield in Syria. We don't have the ability to send in the crime scene investigators to take the DNA swabs. They're very difficult circumstances, but I know on advice that the agencies are very concerned that if that individual came to Australia, potentially hundreds of Australians would die. I do want to see the citizenship of that person cancelled. We had a different process to go through originally. On the advice of the Independent National Security Legislation Monitor, we decided to to renew the law, which we've done. It's reviewable. I think it's perfectly reasonable.
Final one, if this change does get through, are there individuals you're looking at?
Again, there are not a great deal of individuals because the criteria needs to be that you're talking about dual nationals. So some people who were born in Australia but can't, but aren't dual nationals elsewhere, don't come into scope. And again, it's difficult. 100 people or so have been killed in the theatre of war that went to fight from Australia. And we know all up there are about 230 that left our shores, but there are about 250 people who are here in Australia that had their passports or visas cancelled and weren't able to travel across to Syria. So the threat for us hasn't gone away. And the point I'd make is a very, I think is a very, very important one. That is, we have a level of complacency in this country that we don't believe there will be a terrorist attack here. All we need is some lunatic like in Burke Street to have a semi-automatic weapon, and we are faced with the same outcome that we've seen in Paris, in Belgium, in the United States, in the United Kingdom, where 10, 20, 30, 40 Australians die, and only because of the good work of the agencies has that not happened to date. And all of us are working day and night to make sure that it doesn't happen, but there is a sense of inevitability around it given the level of threat, and we need to deal with the reality of it.